Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoyed this legal education content, and today will be the day I earn your subscription. For today's story, we are redoing a story that we did very long ago, but all my appeals have been exhausted on the story, and so we're just going to refilm it and try to avoid the issue that led to it being taken down. So let's discuss a little bit about what happened behind the scenes. So this is episode number 29 in our Capitol Riot series, where we discuss the people who committed offenses against the United States and discuss the evidence against them and discuss possible criminal sanctions that might arise. We've done 57 of these. And for some reason, number 29 of this series was taken down on a community content warning. YouTube decided that this video somehow incited or endorsed rioting or civic distress or civic disruption or some sort of offense like that. And I don't really know how that's possible, because in no video that I've ever done have I ever encouraged anyone to misbehave or defy the law. I've never even suggested that would be a good idea. Not for the least of reasons than for me as an attorney to tell people to break the law poses serious ethical problems. Also, on a personal level, I don't think it's generally a good idea anyway, because of the possible consequences that can result. And of course, this entire Capitol Riot series, like the 1,300 or so videos that are on my channel generally, are simply documenting legal cases. They are documenting what happened in various cases. Sometimes we do Supreme Court, sometimes Court of Appeals, sometimes trial, sometimes ongoing cases. And in every case, we simply try to document and discuss what is going on in those cases. Sometimes the government wins. Sometimes the government loses. Sometimes I agree with the court. Sometimes I disagree with the court. And I always try to provide legal analysis that's intelligent along the way. But I do not, in this video, and have never in any video, encouraged or incited anyone to break any law. And in discussing the January 6 rioters in particular, I am not encouraging anyone to riot in any circumstances. I don't think rioting is good. I do not believe you should riot. I believe that's bad. I do. I genuinely believe it's bad. And that's one of the frustrating things about the thing, is that I've never even begun to encourage it, and I don't begin to encourage it now. So I don't know what that's all about, but that's what's brought us to this place. Anyways, here's what we're going to do. We're just going to refilm the video, and I just want to make absolutely clear beyond clear that I do not endorse or encourage anyone to follow any of the examples in this video. There seems to be prima facie evidence that suggests the people involved in this video have broken federal law. They are, of course, innocent until proven guilty, but we're going to look at the U.S. government's case based on the evidence they have, and we'll try to make at least a probable cause determination about whether or not we think the government has a case. That sounds like a good thing to do. Bringing attention to this and deciding, what it has to decide. All right, so let's do that. So we begin with the FBI's documents in order for the FBI's, or for the Department of Justice's, well, both really, the FBI's charges. What do they think is the evidence that supports the charges that are provided? Well, let's look at the evidence and see what it says. Beginning on or about January the 7th of 2021, and this involves obviously John Herbert Strand and Simone and Melissa Gold are the people that are involved in this particular story. The investigative agencies began receiving tips from the public related to the civil unrest on the Capitol, and several identified Strand as Gold as being involved. Many of the tips included photographs of Strand and Gold inside the Capitol, as seen below. And below we see a picture of Strand and Gold in what appears to be an interior, presumably the Capitol. In another tip, a witness wrote, an old acquaintance was posting pictures of himself taking over the Capitol yesterday. He was calling for a revolution on his social media accounts. Individual broke into the Capitol building as paid to promote propaganda on his website. Again, I'm just describing what a witness described. I'm not saying that's true necessarily, but that's what a witness says. Law enforcement retrieved driver's license photos from both Strand and Gold, both residents of California, and confirmed each were consistent with their appearances above. Also, on January 7th, 2021, the Twitter account, The John Strand, believed to be used by Strand, a pretty reasonable guess, posted photographs in which Strand was seen wearing a black jacket, pink scarf, dark sunglasses, which appeared to be consistent with photographs of Strand and Gold from above. The photograph appeared to be taken on the steps of the Capitol. The photograph shown below also includes the caption, "This is Strand speaking for himself, quote, I'm incredibly proud to be a patriot today, to stand up tall in defense of liberty and the Constitution, to support Trump and MAGA forever, and to send the message we are never conceding a stolen election. I am not saying the election was stolen. I am not making that claim. I am quoting him in what he said, which goes a long way to showing his potential intent and motivation. Not endorsing it, just saying what he said, not saying it's a good thing, not saying the election was stolen. Moving on. Several media outfits broadcasted coverage of the Capitol breach and recorded videos. In their coverage of the event, CNN posted a video on its website entitled, "See Stunning Videos of Rioters Inside the Capitol." In the video, timestamped 2:27 to 2:29 p.m., a man and a woman consistent with the appearance of the above pictures of Strand and Gold can be seen walking with a companion through the National Statutory Hall, which is located in the Capitol. It surely is. I've been there in person. It's a nice place to visit when you're invited. On January 6, 2021, a member of the news media posted a video to Twitter entitled, "Statutory Hall Being Slowly Cleared Out." At 2:58, in the video, a man bearing resemblance to Strand can be seen with a recording device. The man was recording a woman, consistent in appearance with Gold, giving a speech to a small gathering of people. On January the 7th at approximately 9:07 p.m., Twitter account The John Strand, which may have some relation to John Strand, reposted a video entitled, "Trump supporter gets shot and murdered at the U.S. state capitol." It's not the state capitol, it's the nation's capital. Also, the person was shot, to be sure, but murdered is a legal determination, which I'm not necessarily endorsing. The video was posted with the caption, "I was there, this is inexcusable." The tweet was tagged as posted from Washington, D.C. with Twitter for iPhone, so we got some location tracking on the Twitter. A review of several tweets from the account holder, The John Strand, includes the term Twitter for iPhone. Based on my training and experience, I understand Twitter account holders who own or possess Apple iPhones can download Twitter applications from the App Store. Once the applications load on the phone and a user broadcasts a tweet, it's often tagged with the term Twitter for iPhone. Now, this may seem a little bit basic, but then again, you have to remember that you can't necessarily guarantee the judge that is going to be reviewing this at any particular stage necessarily knows this, and like what a Twitter is and how it works and why it would be labeled that way, right? So you got to kind of lay out some basics sometimes, particularly because you never know who will be viewing this and what their level of technical competence is. So sometimes you got to explain the basics. An open source search of social media depictions from January the 6th uncovered several videos and photographs of people consistent with Strand and Gold inside of the Capitol. Some of the photographs are below. And below we see a picture of Gold and Strand with microphone and bullhorn in what appears to be Statutory Hall inside the Capitol. You can see the statues behind them. We see Strand and Gold again in the interior. We can see the doors and the molding, the crown molding on the walls. We can see them taking selfies together and pictures together inside of the interior of the building with the velvet rope there. And we can also see them walking interior with them together. And we see them wearing the same outfit from place to place, which helps us identify. You know, when you wear a pink scarf and the sunglasses, it does help a lot with the identification from place to place, you know. So if there's some decent evidence that suggests they were in the interior of the building that day. Video posted to Getty Images database online shows what appears to be Strand and Gold in a large crowd attempting to push past multiple officers blocking the entrance to the Capitol, which had visibly broken windows at the time. One of the officers, who had been pinned near the doors to the Capitol, appears to be pulled away by someone in the crowd and lands near where Strand and Gold were standing. So this is like, yeah, again, we have officers that are attempting to block their path. Right? There has been suggestion, and I am not saying this is true. I'm just merely noting it, that some people were basically allowed to enter the Capitol by police. Some of them clearly were not. We have seen pictures and videos of people breaking windows. We've seen pictures of people opening up the doors from the interior once they got in from the broken windows by, pushing the lever to open the doors from the inside. And we have seen, as we see here, people attempting to push back past officers who are attempting to prevent them from entering. So I can't speak to every person who entered the building that day, nor am I attempting to. I can say for these particular people, it appears these particular people were not being ushered into the Capitol. It appears these particular people were being resisted by Capitol Police, which goes a long way to showing a trespass when the police are trying to stop you. So, do some people potentially have some kind of defenses when it comes to trespassing? Yes, possibly. Although, strictly speaking, in the Capitol Riot series, we haven't seen any of them that we've covered, but it's at least hypothetically possible. Is it possible for these particular people? Doesn't seem that way, because these particular people are being actively resisted by the police, whatever might be true for anyone else. And as we all know, when it comes to any sort of criminal charge, every case has to be evaluated unto itself. Everyone's facts are going to be a little bit different, and these particular facts do not support any such defense of we were allowed in. Apparently not so much, because we see them on video actively trying to get past an officer who's trying to prevent them from getting in. Or so it at least appears. Here's a picture of them doing exactly that. I conducted an initial review of some of the surveillance footage from surveillance cameras inside the Capitol. During my review, I saw what appears to be Strand and Gold, as depicted above, entering the Capitol through the rotunda door and walking past through various parts of the building, consistent with their locations as captured on other devices described above. So we got them, how do we know these people? Well, they took some pictures in the interior. We saw them taking some pictures in the interior. We have some pictures from closed caption. We have some pictures from surveillance. We have pictures from social media. We have them posting on their own social media pages, as is so common for so many of these people, posting about their own day at the Capitol and giving, pretty good prima facie evidence to the police that would warrant, further investigation. So, got some decent evidence that's going into this. On January the 8th, agents from the FBI interviewed a witness who identified Strand as a person on the FBI wanted poster from the Capitol breach. The witness met Strand approximately 10 years ago and has a personal relationship with. Witness 1 provided a phone number for Strand, which is consistent with the phone numbers the investigative agents believe Strand to use. So this guy was originally posted on one of the FBI site or whatever as, information wanted about, person of interest. And someone said, hey, I recognize that guy. It's Strand. And so, the police the FBI based on that went to do some further research. And yeah, it was Strand. And then when they were able to confirm who it was, started to put together a picture about what happened that day with respect to Strand. Whatever might be true of anyone else. On January the 12th of 2021, the Washington Post published an article saying, I do regret being there. Simon Gold, noted hydrochloroquine advocate, was inside the Capitol during the riot. Apparently he is telling the Washington Post, I regret being there, which necessarily means what? He was there. The article features an additional photograph of what appears to be Gold inside the Capitol, giving a speech as captured in the video described in paragraph 17 above. In the article, the writer quotes Gold as stating the following in a phone interview. I can certainly speak to the place I was. And it most emphatically was not a riot. Where I was incredibly peaceful. Well, maybe where you were, but then again, you know, you were actively participating in an event that, you know, could be reasonably characterized as a riot under both colloquial and legal definitions of the term. You know, and even if you were peaceful, you know, strictly speaking, right, your participation may be enough to implicate you, possibly, under the relevant law. And maybe you didn't see any rioting, but, you know, you presumably did see when you were trying to get past the police officer who appeared to be trying to prevent you from getting in. So, there was that. Whether or not that's rioting in your view, I guess. According to the article, Gold confirmed she went inside the Capitol. She says that, saying she followed the crowd and assumed it was legal to do so, further knowing she was inside for 20 minutes and regretted being there. How she assumed it was legal when, again, the video evidence appears to depict them actively resisting an officer who's trying to prevent them from getting in, one only can begin to wonder how they possibly came to that conclusion. Also, as we've pointed out, like, the entire premises were surrounded by a fence that said, you know, no trespassing, and, you know, the guards trying to prevent you getting in and stuff might have been clues. But they say apparently they thought it was legal somehow, which seems like a strange conclusion, but okay. According to the article, Gold added she traveled to D.C. to speak for the Rally for Health Freedom on the east side of the Capitol on Wednesday afternoon. According to the article, Gold claimed to have attended the rally along with John Strand, who was there to ensure her safety. The article includes the photograph below, which is credited to John Strand, which again shows them inside the Capitol building at the Statutory Hall. Now we see behind them an officer who is at that moment not necessarily doing anything. Is that necessarily a legal problem? No, because of what we discussed before, right? Right, the police don't necessarily have to stop you to try to be illegal, for it to be illegal, right? And the police can choose to act or not act for all kinds of tactical or strategic reasons. It is legal as long as the police are not encouraging you to break the law. But if they're merely being passive, right? If they're merely being passive, that is not entrapment, right? And everyone is presumed to know the law, as we all well know. So if the police officer is merely standing by and you break the law, the fact they're merely standing by does not entrapment make. In order for it to be entrapment, they would have to encourage you. And, more to the point, on top of that, the encouragement would have to be such that would not be of character to you. So it would have to be something that would go against your natural inclinations. So that would be something else you'd have to demonstrate. You'd have to show that essentially it overcame your will. So merely the police encouraging it isn't considered legal entrapment either under the law. I'm not saying this is good or bad. I'm just describing what is, because this is a legal education channel and you should know what entrapment looks like. It's not only when the police are encouraging you to do something, it's when they do it in a way that overcomes your will. And a good way to demonstrate that would be, for example, to show that you are not particularly inclined to that kind of illegal behavior. If you have previous convictions relating to that kind of previous behavior, you're going to have a difficult time showing its entrapment for that reason. Not saying it's impossible, I'm saying it's difficult. And again, not saying it's good, I'm saying it's the law. This is a legal education channel. Moving on. Okay, so the FBI believes a whole bunch of things as a result, but we don't really care that much what the FBI thinks, because we have what the grand jury thinks. And we'll discuss what the grand jury thinks, which is better than what the FBI thinks, right? So a grand jury has returned an indictment against John Strand and Simone Gold, John Herbert Strand and Simone Melissa Gold to be precise, for the following charges: obstruction of an official proceeding, entering and remaining in a restricted building or grounds, disorderly and disruptive conduct in restricted buildings, disorderly conduct in the building, parading, demonstrating, or picketing inside the building. Let us read the actual indictment and see what we think about these potential charges on a probable cause standard. which is all you need to indict. It's not the same thing as a finding of guilt. It's a lot less than that, as I'm sure we all know. Count 1, the grand jury charges that on or about January 6th, which is very typical legal language, within the District of Columbia and elsewhere, John Strand and Simone Gold attempted to and did corruptly obstruct, and the word corruptly there goes to show a improper motive or improper reason, because how could you obstruct or influence or impede a proceeding? So one of the questions you might want to ask yourself is how can you non-corruptly influence a proceeding? And the answer to that's pretty simple, right? Protected speech, right? So if you're merely demonstrating outside the Capitol grounds, or calling your congressman, or writing them a letter or an email or something, right? If you're doing that, you are obviously trying to influence them to do something, which is a protected First Amendment right. In that circumstance, you have a right to petition for redress. It's in the First Amendment, right? So you can attempt to influence your congressman in all kinds of fun legal ways, right? You can make TV ads or movies or news articles or websites, social media, phone calls, letters, legal protests, right? But then there's this corruptly, which means that you're, in defiance of law, basically. Not so much with the First Amendment. Corruptly obstruct, corruptly influence, or corruptly impede an official proceeding, namely a proceeding before Congress, by entering and remaining in the U.S. Capitol without authority and committing an act of civil disorder and engaging in disorderly and disruptive conduct. There seems to be some prima facie evidence available for that charge on a probable cause standard. Moving on to count 2. On or about January 6th, within the District of Columbia, Strand and Gold did unlawfully and knowingly, again, mens rea, knowingly, enter and remain in a restricted building and grounds, that is, any posted, cornered off, or otherwise restricted area within the Capitol and its grounds, where the Vice President were temporarily visiting without lawful authority to do so. Or Vice President-elect, the Vice President and Vice President-elect. Okay, so we have to show that they knowingly did this. Knowingly entered in or remain grounds. So how would they show that they knowed? For example, we have at least some prima facie evidence that would suggest that, as we see them as part of a crowd attempting to get past an officer who, at least according to the FBI's description and the video still, appears to demonstrate that they were trying to get past an officer. So that would go a long way to showing that you were knowingly entering a restricted building. If true, that would be, for example, how you show that you know that. So merely entering and remaining in the restricted building is not enough. You have to show that it's knowingly. And at least we have some evidence that would suggest knowingly. Moving on to count 3. Strand and Gold did knowingly, there's that word again, and with intent to impede and disrupt. So again, it's our goal, what we're trying to do. Impede and disrupt the orderly conduct of business and official functions. Engage in disorderly and disruptive conduct in and within proximity to a restricted buildings and ground, that is, any posted, cornered off, or otherwise restricted area within the United States Capitol and its grounds where the Vice President and Vice President-elect were temporarily sitting. And the conduct did, in fact, impede and disrupt the orderly conduct. Well, did, in fact, impede, we've got, and then show knowingly and with intent to disrupt. There seems to be some decent evidence that would tend to suggest that on a prima facie standard as probable cause. Count 4. On or about January the 6th, 2021, Strand and Gold willfully and knowingly engaged in disorderly, there's that thing, willfully, intentionally, purposefully, willfully and knowingly engaged in disorderly and disruptive conduct. Did they know and were they intending to engage in disorderly conduct? Again, seems kind of plausible, right? In any Capitol buildings with intent, and there's that intent again, to impede, disrupt, and disturb the orderly conduct of a session of Congress. Seems like we have some prima facie evidence to support that. Count 5, willfully and knowingly paraded, demonstrated, and picketed in the Capitol building. Again, we saw them apparently doing that with their bullhorn and other things that would tend to show some sort of intent and or knowledge on their part. So, on a prima facie standard, probable cause standard, there is enough evidence to suggest that these charges are warranted. Of course, they are always innocent until proven guilty, and at the risk of repeating it and beating a dead horse, I am not encouraging anyone to riot. I don't know how you could possibly perceive me reading official FBI and DOJ documents detailing people's crimes and then detailing what they're being charged with and doing a legal analysis. I don't know how you could possibly perceive that as incitement or encouragement, but apparently YouTube seems to think somehow it is based on their prior actions with respect to a prior video. And I don't know how that's possible, but that's where we are. So just to make absolutely clear, beyond any doubt, I do not encourage anyone to riot in any context, whether left-wing or right-wing. I don't encourage anyone to riot, whether it's BLM or Proud Boys or Antifa or Oath Keepers or anyone else. I think it's all equally bad. I think everyone who breaks the law should be punished. I do agree with many people who are very critical that not all the people, for example, who engaged in certain events during, the summer proceeding, were necessarily held to account. Now, in many of those situations, if not most, if not the overwhelming majority, that's state law violations, not federal. So that brings, at least one difference why we didn't see a lot of DOJ or FBI charges, although that's not universally true. For example, when they were trying to, disrupt the courthouse and I believe Portland, that may have raised federal issues. And some of those, although not necessarily all of them, were prosecuted. And I think that's not great. I think people who break the law should be prosecuted. But I don't think the solution to my misgivings is to say these people should not be prosecuted based on this evidence, because I think everyone should be prosecuted based on this evidence. So my reason for being upset, to the extent it exists, is not that these people are being prosecuted, but that other people who might, in some sense, be potentially comparable for at least their violations of various federal laws are not equally being held to account, and that's unfortunate. But I think it's okay to say that, these people deserve the swift forces of justice, and also perhaps other people who did other things should also be held to account. Incidentally, I would point out that that the federal statute of limitations is 5 years, so maybe some of those will still be brought to light, but perhaps not others. In any event, I do not believe it is good to riot. I do not believe it is good to disrupt proper lawful authority. I don't believe it's good to push past police officers. I don't believe it's good to disrupt a lawful exercise by Congress, and I don't believe any of that's good or should be encouraged. So hopefully that's enough. That last count seems to be unconstitutional, making a crime to protest or picket in any U.S. Capitol building. You got to read the charge more carefully. Willfully, knowingly paraded, demonstrate, and picketed in any United States Capitol building. That's a time, place, manner restriction. That's a time, place, manner restriction, right? Under First Amendment law. So we discussed this, right? You can't do it in the building. So you need intermediate scrutiny, right? Because it's a time, place, manner restriction. You cannot parade, demonstrate, or picket inside the building. So it's intermediate scrutiny. It's not based on subject matter, right? It's not based on viewpoint. It's a universal thing, no matter what you are trying to protest for or picket for. So it's not subject matter, it's not viewpoint based. It's a time, place, manner restriction. So you can never protest or picket inside the Capitol building. That seems to be constitutional under intermediate scrutiny. So I don't think that's a particular problem based on First Amendment analysis. You have a right to redress grievances. You do, right? You have a right to redress grievances, and we've discussed many of the way you have the right to redress grievances. You can, and petition, more specifically, petition for redress of grievances. to be proper under the First Amendment, which is always nice to use the exact words, right? You have the right to petition for redress of grievances. Well, how can you lawfully petition? Many ways. You can write letters, you can circulate petitions, and get signatures, you can send emails, social media, you can call your congressman, you can, write them, you can schedule times to meet with them, either at Congress or at their home districts. You can run ads against them or for them. You can run commercials, write an editorial. You can make a movie. You can many, many ways to petition your government for redress of grievances, right? So there's many, many ways to properly redress. One of them is not inside the Capitol building, which again is a time, place, manner restriction, which does not appear to offend the First Amendment, because it appears to be a substantial government interest, which appears to be substantially related to a legitimate means, or narrowly tailored, or however exactly the First Amendment analysis is worded on that. But yeah, you have lots of ways to petition. This is just not particularly one of them. And incidentally, these kinds of restrictions are well within the confines of the First Amendment, right? This is nothing like special about petitioning for redress of grievances. We discuss this in the First Amendment all the time when it comes to just freedom of speech or freedom of press or, freedom of religion or anything, right? It all like the same First Amendment analysis we've discussed time and time again, so it's fine. Provolone Love says, gives $5, says, love your work on channel, Kurt. Keep at it. I'm glad this is an outlet for you to learn about the law and help idiots like me learn a bit too. No problem. I got it. Where's what written? Please. Time, place, manner restrictions? I mean, I could go dig up the relevant Supreme Court law, Supreme Court cases. I don't remember off the top of my head which one is the one establishes it. But these are I'm just telling you what it is. Under the relevant law. I'm a legal educator. I'm telling you what the law is, right? So under our constitutional system, we have 3 standards of review, right? We have rational basis, where the vast majority of regulations live, vast majority of laws live, intermediate scrutiny, and then we have strict scrutiny. All right, so we can go through those real fast. So the overwhelming vast majority of laws live in rational basis land, where you just need any legitimate government interest and any legitimate means. So you need any legitimate means and any legitimate end. Obviously, this is a pretty easy standard to meet the vast majority of the time. Any legitimate means and any legitimate end. So, and also, the courts will go out of their way to find one. So the Congress or legislature doesn't even have to tell you what it is. And if they do tell you what it is, that is not the reason they're stuck with. The courts will find any basis, any rational reason, any legitimate end, and any legitimate means is fine, right? And that has some sort of rational basis. It's pretty low. It's not infinitely low, because we can go one step below that where it's not okay. Arbitrary and capricious, right? Can't do that. Can't do arbitrary and capricious. So no wearing brown socks on Thursdays. It's no. Right, that's not going to fly. Why? It doesn't make any sense. So that's your bare minimum. Intermediate scrutiny, next step up, right? We need a substantial government interest, and it needs to be substantially related to that end, right? It needs to be both, they need to match, right? And sometimes the language gets a little bit changed on that last element a little bit, but that's basically what you're looking for, right? So it's not just any interest, now it's a substantial governmental interest. Okay, so things that typically live at this place, like First Amendment law, time, place, manner restrictions. When it comes to discrimination on the basis of sex typically lives in intermediate scrutiny. So those are the 2 that I know of off the top of my head. And unfortunately, at least under the current law, until the Supreme Court changes it, basically all the Second Amendment regulations ever. And then even they treat those standards pretty shittily. But basically everything that's not an outright ban in the Second Amendment, at least as a matter of law at the moment, is treated under Second Amendment, as treated under intermediate scrutiny, which doesn't make any sense, but that's where we are. And then at the top of the pyramid is we need a compelling governmental interest, and it needs to be the least restrictive means. So it needs to be overwhelmingly important, and it needs to be basically the least that's possible, which is very hard for the government to meet. It occasionally happens, but it's hard, as the name suggests. And there you're thinking about, for freedom of speech, you're thinking, First Amendment, you're thinking about subject matter restriction or viewpoint matter restriction is typically what lives there in First Amendment land. You're thinking about, in Second Amendment, like the core of the Second Amendment, which at this point is pretty shallow, but hopefully the Second Amendment the Supreme Court will fix that soon and extend it a little bit more. But yeah, you think about the core aspects of the right. And so, yeah, okay, well, that's, your basic constitutional analysis. Jim Stellata says the Supreme Court has struck down restrictions at City Hall all around the country. So are the rules different from Congress? No. What is the nature of the restrictions they're striking down at the town halls, though? What is the nature of the restriction? And then you have to get into the analysis, right? So, and again, you have to find like a substantial, if it's time, place, manner restriction, you need to find a substantial governmental interest, and it needs to be substantially related to that interest, which, requires a bit. So it's like, yeah, every restriction just because it's at town hall survive? No, of course not. That would be dumb. Does that mean that every regulation on the First Amendment would even survive at Congress? No, of course, that would be dumb. So it's not like everything just because of the location. But this seems to be within the bounds. So if you say to me, the Supreme Court has struck down a whole bunch of town hall regulations, my question would be, okay, what exactly are the nature of those regulations? And to what extent, if any, are they comparable to this? And, can you make a straight line comparison? Or is it different? And so, that would be my question back. Salty says this is unwatchable. I don't know what to tell you, Salty. I'm just giving you legal analysis. I don't know. I can't tell you what you want to hear, Salty, nor would I necessarily be a good legal educator if I did. I'm trying to describe to you the law as best as I can. I'm sorry if it's unwatchable, but I can't lie to you. It wouldn't be in your interest for me to lie to you. I'm telling you what the law is as it sits right now. For better or worse, this is where things are sitting, based on, my fairly comprehensive legal opinion. And so I don't know what to tell you, except this is what the law is. And I'm sorry if that makes it unwatchable, but I'm not going to give you any other answer other than my best legal analysis. So, yeah. The issue is political. It's fine. We're enjoying. Yes, I think that's one of the reasons. I think that's exactly one of the reasons it's so important to be legally pure, which I attempt to do, which is exactly why I made a point of saying, right, that I apply the standards the same way. Like, I consider myself conservative. I consider myself Republican. Some of the people in the chat may disagree with that, but I consider myself to be a principled person. I consider myself to have standards that are principled. And those principles are going to apply universally because they're principles, right? If I believe in law and order, as I do, as a Republican, if I believe in the law, as I do, as a Republican, if I believe in the rule of law, as I do, as a Republican, as a conservative, I am going to apply that evenly across the board. Left or right, up or down, I don't care. I don't care if it's Antifa. I don't care if it's Proud Boys. I don't care if it's BLM. I don't care if it's Oath Keepers. I don't give a damn. I don't care, because if I did care, it would make me non-principled. All right? I'm going to give you the law, and I'm going to apply it evenly, no matter who it helps or hurts, because, that's what a good jurist should probably do. Right? I'm not going to apply different standards to different kinds of people because I feel like it, because that would be bad. Sometimes the law is not meted out correctly. I agree with you. Sometimes the law is not applied correctly or applied correctly or universally. I agree with you. In reality, if you want to say in reality the law is not applied evenly, or the law is not applied equally, the law is not handed out equally, I will not disagree with you. As I said, and I made a point of this saying earlier, like in my view, many of the people in the BLM Antifa stuff that happened in the summer of love was very illegal, although not necessarily under federal law. So it's a little bit different, but not that much different. So in my view, many of those people should have been prosecuted. The fact they're not is endlessly irritating. But that is not going to change my legal analysis, right? My being upset that other people, or my being upset that the police or the judicial system in general is not applying the law evenly is not a good reason for me not to apply the law evenly, because I'm principled, even if everyone else isn't, right? So it may be true, and probably is true in many circumstances, the law is not handed out equally. I'm not going to disagree with you. I just don't think that's a very good reason for me not to apply the law evenly. So, I mean, that's what I think about that. Sledge and Wed says, seem to remember sitting members of Congress protesting while sitting on the floor, obstructing the regular business of the Capitol building. Aha! Well, my friend, Sledge and Wedge, as it applies to members of Congress who are sitting in the Capitol building or the floor of the Congress, obstructing the business of Congress, my friends, they have a special provision in the Constitution just for them. It's true. Right, and we're going to apply the Constitution no matter what we think, because we're good legal advocates, right? So we are going to apply the Constitution for better or worse, and the Bill of Rights for better or worse, right? Because that's how we roll, right? So are members of Congress special when they're sitting on the floor of the Capitol or they're sitting on the floor of Congress? They sure as hell are. Why? There's a provision in the Constitution specifically for them. And it says very clearly that no member of Congress can, well, I'm going to paraphrase it slightly, but no member of Congress shall be held to account in any other place other than Congress for their official duties as it relates to Congress, right? So, for example, if a member of Congress were to get up during a floor speech in Congress and start revealing classified information, top secret classified information, could you prosecute that congressman? No, you can't. No, you can't. You can expel them from Congress because each House of Congress is able to imply discipline to its own members. So you can expel them. But can you prosecute them? No, you can't. Because there's a provision in the Constitution that gives the members of Congress immunity. The more you know. It's true. My hair, including my eyebrows, is its natural color. Yes, so if you're looking at my eyebrows, yes, they're my natural color. That's a strange comment, but okay. Yeah, the speech and debate clause. That's the one you want. The speech and debate clause basically says, yeah, nothing that's said shall be questioned in any other place. So if it's speech, they get special protection because it says so. So, end of that analysis. Yeah, it may be wild, but it's the law. It's the law. Jim Stellata says there was a case that went up to the Supreme Court concerning protesting in Chicago City Hall. They struck it down in the 80s. Again, I'd have to know a little bit more specifically about the case, and I'd have to know a little bit more about the Supreme Court's reasoning, right? It might turn on the specific reasoning of the case. If you happen to know the name of the case, I'm happy to pull it up. We could read it, and we could see to the degree to which this provision is consistent with that or not, right? So if you happen to know the name of that case from the 80s with the Chicago City Hall and the protesting thing, we can read it together and we can discuss whether or not this provision in the law is consistent with that Supreme Court holding or not, right? We'll go through the specifics and we'll see how close it fits. That's always fun, right? Someone asked why they're on the same charging document. I'm not sure if they're married or not, but they were basically connected at the hip for the purposes of the day. So It makes total logical sense to charge them both in the same document because they both were together the entire time and both doing the same thing. So married or not, for purely efficiency reasons, it makes sense. Karen says, fact, I find law all confusing. Well, that's one of the reasons I'm here. I find trying to understand the way bar has come in and created a false door. I'm not on their side. I assume by bar being in all caps, you're referring to some sort of idea. The Bar Association is really like a British registry of lawyers or something, which it's not. And we pledge allegiance to the Queen, which we definitely don't. And yeah, so no. Congress and the Supreme Court have given themselves more privilege without the people's consent. Again, no, they haven't. As it relates to the speech and debate clause, as I mentioned, it's in the Constitution. So they gave themselves the privilege by it being in the Constitution, which was ratified by the states, as I'm sure you well know, through the people and blah, blah, blah. So yeah. Sledge and Wedge says, do you think America could use more or less laws? Hard to say in the abstract whether or not we could use more or less laws. It's hard to answer that question in the abstract. So how can you charge a member of Congress with treason if they have immunity? They have immunity for respect to things they say on the floor. They have respect to their speech. So in so much as a member of Congress, what they're saying is on the speech, again, you can't charge them with treason because it can't be questioned in any other place. So to the extent that they're within the bounds of the speech and debate clause, then you can't charge them with treason or any other crime. So again, if you had a member of Congress who just got up and during a floor speech just started spilling classified information, even if that was to assist, even if you could prove, even if they confessed to the fact that they were doing it to assist an enemy in war, right, and admitted to it in open court, you still couldn't charge them with treason because it shall not be questioned in any other place, which means you can't charge them because they have immunity. So, yeah. Now, that doesn't mean you can't charge a member of Congress with treason, period, because the speech and debate clause covers speech and debate. So there's a lot of things they could do outside that might get you there, but not if it's, on the floor speech. So it's not infinitely elastic, but it provides you as much immunity as it has. Are hearing speech? Yes. To the extent that members of Congress are speaking during hearings? Sure. Yeah. No problem. It's official proceeding of Congress. If a member of Congress is doing it during hearing, that would count. It has to be during a congressional session. If they go to their office and do it, they can be. This can be true, right? We know it extends to the floor, and we know it extends to a committee hearing. Whether or not it extends to their office, we're not 100% sure on that one to be sure, but you can't just say unequivocally, but yeah, if it's in their office, you're a lot closer to it being outside the bounds. But sleeping with a Chinese spy does not count as speech and debate, I'm pretty sure. Does it cover Twitter? Good question. I don't know. Members of Congress have argued it. I believe Elizabeth Warren argued it, in fact. And I believe, I'm trying to remember, did the court agree with her? I think they might have, with speech and debate on the Twitter thing. So I think it's undecided, but maybe? Question mark? The idea is adopted from British common law known as parliamentary privilege. Yeah, right. It's, exactly the same concept. Yeah. Do I study existentialism or Aristotle in law school? No. You don't study philosophy in law school explicitly. I mean, I'm interested in philosophy, but I know about Aristotle, but did we ever get a name of that 80s case from the Chicago thing? Did we ever get that case? Because I was just waiting and seeing if someone was going to tell me the name of the case from the 80s. So did we ever get the name of the case with the 80s, with the Chicago City Hall or whatever it was? Because if there's a case out there, I'm happy to read it and try to decide whether or not it's consistent with this, because I'm a good legal educator, and I'll tell you if it's different or not, and I'll explain why. So does anyone see what name the case was? I can't find the case I'm thinking about from Chicago, but I know they used Cox versus Louisiana as precedent. Had to do making a crime to block hallways at City Hall. So do you want me to go look up Cox versus Louisiana? I mean, if that's precedent, you want me to go look that up? We can pull it. Let's take a look. I can pull this up real fast. Let me just pull it up on Google Scholar. We'll download and discuss it. It'll be fun. Cox versus Louisiana, 1965. We'll save this as a PDF in my little stories box, and I will open it up. Print. Save as PDF. More settings. Let's see, scale. I like to do 125% because it's a little small at 100%. Save that. Put it in my stories box. Great. Open that. Great. All right, let's do this thing. Let's discuss this thing. This will be fun. What about Swalwell versus Spy? I told you. Right, the speech and debate clause covers speech and debate on the floor. It obviously doesn't cover things beyond that. So, yeah, I mean, it's totally possible he's guilty of some crime. It's not infinitely elastic. But yeah, thanks for the question. Let's cover this case, Cox versus Louisiana, and see the degree to which it might read on our present situation or not. All right, so let's see. All right. Appellant, the Reverend Cox, a leader of a civil rights demonstration, was arrested and charged with 4 offenses under Louisiana law: criminal conspiracy, disturbing the peace, obstructing public passages, and picketing before a courthouse. In a consolidated trial before a judge without a jury on the same set of facts, he was acquitted of criminal conspiracy, but convicted of 3 other offenses. He was sentenced to serve 4 months in jail and pay a $200 fine for disturbing the peace, blah, blah, blah. In accordance with Louisiana procedure, the Louisiana Supreme Court reviewed disturbing the peace and obstructing public passages conviction on certiorari, and the courthouse picketing conviction on appeal. The Louisiana court, in 2 judgments, affirmed all 3. Appellant filed 2 separate appeals from these judgments, contending that the 3 statutes under which he was convicted were unconstitutional on their face and as applied. Well, for picketing the courthouse, that doesn't sound constitutional. Disturbing the peace, maybe. Obstructing public passages, that sounds okay. It sounds okay to ban that, but let's see what we got. All right, so in 1961, 23 students from Southern University were arrested in downtown Louisiana for picketing stores that maintained a segregated lunch counter. Okay. This picketing, urging a boycott of these stores, was part of a general protest movement against segregation, directed by whatever. The appellant, an organized minister, was an advisor for this movement. On the evening of December 14th, the student president of the local chapter spoke at a mass meeting at the college. The students resolved to demonstrate the next day in front of the courthouse in protest of it and the arrestment and imprisonment of the pickers. That sounds constitutionally proper to me. Although it can get a little bit tricky because you can get into, like, you can limit protesters outside a courthouse to the degree it would influence the jury. So, like, if the jury, this would most often be a problem when it comes to the jury deliberations rather than the trial. So you can limit picketers so that they're not, like, audible to the jury, because again, that would be like a time, place, manner restriction. But generally, picketing outside the courthouse is going to be fine. So let's see. The next morning, 2,000 students left campus, which was located 5 miles. Most of them walked. Cox felt his duty to take over the demonstration and see it was carried out. When Cox arrived, 1,500 to 2,000 students were assembled at the site of the old Capitol building, of the old state Capitol building, 1 and 2 1/2 blocks from the courthouse. Cox walked up and down, cautioning the students to keep to one side of the college sidewalk while getting ready to march for the courthouse. The students circled the block and filed 2 or 3 abreast, occupying about half the sidewalk. The police learned about the proposed demonstration the night before. Blah, blah, blah. Someone asked them to disband the group. He did not acquiesce, but told the officers they would march to the courthouse, say prayers, sing hymns, and conduct peaceful program of protest. Okay, that all sounds okay so far. They walked in orderly and peaceful, legally. They walked in orderly and peacefully file, 2 or 3 abreast, stopping for a traffic light in the center of the block. They are joined by another group. This all sounds legal so far. As Cox still had the group approach the vicinity of the courthouse, he was stopped by Captain Whatever, asked him about his purpose. He must confine his demonstration to the west side of the speech. The west side of the street might depend on exactly why the instruction's being given again, because we talked about this a little bit. This, of course, was not, I did not do import as giving him permission to do it, but as present with the situation that was accomplished, had to make a decision. You don't need to give permission for a lawful protest. Sounds fine. The students were then directed by a sidewalk across the street from the courthouse, 101 feet from the steps. This sounds fine. Lined up on the sidewalk about 5 deep. The group did not obstruct the street. It was close to noon. 70, 80 policemen were stationed between 2 groups. Rain fell throughout the demonstration. This all sounds legal so far. Several of the students took from beneath their coats picket signs. They sang some songs. And 23 students were locked in jail, responded by themselves singing. This was in turn by an applause by the demonstrators. Sounds okay. There were state witnesses described as muttering and gumbling by the onlookers. The sheriff deeming the appeal to students to sit at the lunch counters to be inflammatory, which incidentally doesn't make it illegal. Inflammatory is not illegal. Incitement is, but not inflammatory. Now, you've been allowed to demonstrate. Up until now, your demonstration has been more or less peaceful. What you're doing now is direct violation of law. A disturbance of the peace has got to be broken up immediately. I don't think so. Not under these circumstances. The testimony is that what happened then. Some of the state witnesses says that Cox said don't move. Others said he made a gesture of defiance. It's clear from the record they did not break up the demonstration. Almost immediately thereafter, the policemen expelled tear gas. That sounds bad. No one was arrested that day. The only person that was arrested was a young white man, not part of the demonstration, because he was called to disturbance. This all sounds legal to me. Okay, they're charged with breaching the peace. That sounds fine to me. We hold Louisiana men not constitutionally punish appellant under the statute for engaging this type of conduct, which the record reveals, and also the statute is authoritatively interpreted as unconstitutionally broad in scope. Yeah, that sounds fine. The loud clearing and chopping by students in response to singing converted it from a peaceful assembly into a riotous one. I don't think so. It's true the students cheered and applauded. However, the meeting was outdoor meeting, and a key witness said while the singing was loud, it would not be disorderly. That would be pretty hard. There's no indication the mood was ever hostile or unfriendly. It's not riotous. It reveals the students cheered and clapped, were well behaved. It sounds like an improper conviction for rioting or breaching the peace. That sounds all like crap. Our conclusions, the record does not support the contention students cheering, clapping, and singing constitute a breach of peace. Yeah. And apparently, because the judge convicted him on the basis that it's inherently dangerous in a breach to bring 1,500 people to a predominantly white business district, that's bullshit. Right? That's not inherently breach of state. Should be sustained because of fear that violence is about to erupt. Bullshit. Okay, statute, blah 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 blah. Okay, the conviction for the conviction for breaching the peace is total bullshit, right? It's like we don't have to do a lot of legal analysis on that, right? They're just outside the courthouse singing and cheering and clapping and behaving peacefully, and yeah, that's pretty much First Amendment protected conduct, and we don't have like some sort of special reason to prohibit them, like there's a jury that might be, we don't have anything like that. So under these facts, this is a total bullshit conviction, and we all know it. All right, let's go to the obstruction of passages. Okay, we now turn to validity of the conviction for violating this statute, which provides that no person shall willfully obstruct free and convenient use and normal way of any public sidewalk, street, highway, bridge, alley, road, or other passageway, entrance, corridor, passage of building, structure, blah, 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 blah. And then it talks about an exception for labor standards. Okay, so I'm going to guess right away that I'm going to guess, although I'm not sure, and we'll see if I'm right or not, that this is going to turn on a factual distinction rather than a legal distinction, right? I'm going to guess this is going to turn on the fact that they were not, in fact, obstructing anything. Because as the facts were recited, right, they were only blocking like half the street or half the sidewalk, right? The other half was open, right? And they were 100 steps away from the courthouse, right? So they weren't like blocking the entrance. And I assume if anyone was trying to get through, that like they weren't trying to prohibit anyone from getting through. Like if you could show that, maybe. But I'm guessing this is going to turn on a factual distinguishment. Like they were not, in fact, obstructing the public passageways or something, right? They're only taking up half the sidewalk. They're not taking up the whole thing. So this is going to turn on facts, not law. Which would make, if that's true, would make quite a bit of difference, right? And also, because at this point, they're talking about the exteriors of things. They're not talking about interior things, which also makes a difference, right? You should not obstruct the free use of a public sidewalk, street, highway, bridge, alley, road, or other passageway or entrance corridor of any public building. Now, if we can show them inside the building, that would be a lot closer. But let's see what happens, because I don't think, based on the facts that we saw, we had that. So let's see. Appellant was convicted under statute not for leading the march, which the Supreme Court said had been orderly, but leading the meeting on the sidewalk across the street from the courthouse. Yeah, this is going to bullshit on the facts. In upholding the conviction, blah, blah, blah. Appellant, however, construes that as to construe and apply in this case the statute's unconstitutional infringement on speech. The contention on facts he presents raises an issue which the court has dealt with in many decisions. The right of the statute of municipality to regulate the use of streets and other facilities to assure the safety and convenience of people in their use, and right of the people of free speech of assembly. From these decisions, clear principles emerge. The right of freedom of speech and assembly, while fundamental, still does not mean that everyone with opinions or beliefs to express may address a group in any public place at any time. The constitutional guarantee of liberty implies the existence of an ordinary society maintaining order, without which liberty itself would be lost to anarchy. The control of travel on the streets is a clear example of governmental responsibility to ensure the necessary order. A restriction in retaliation designed to promote public convenience in the interest of all and not susceptible to abuses cannot be disregarded by the attempted exercise of some civil rights, which in other circumstances would be entitled to protection, which sounds a lot like a time, place, manner restriction. One would not be justified ignoring a familiar red light because it was thought to be a means of social protest. No one could, contrary to regulations, insist on a street meeting in the middle of Times Square as a rush hour as a form of protest. Government authorities have a duty and responsibility to keep the streets open. A group of demonstrators could not insist upon the right to cordon off a street or entrance to a building and not allow anyone to pass. Yeah. We emphatically reject the notion urged by the appellant that First and 14th Amendments afford the same kind of freedom to those who would communicate such as patrolling, marching, and picking ideas on the streets, as those who communicate their ideas by pure speech. It has never been deemed an abridgment of freedom of speech or press to make a course of conduct illegal merely because the conduct was in part initiated by speech, right? Because just because it's speech does not necessarily make it constitutional because of time, place, manner restrictions and other things that we've discussed, right? So just because I know it's speech is not just quite the end of the analysis. Yeah, that's not going to be quite enough. We have had no occasion in this case to consider the constitutionality of a uniform, consistent, and non-discrimination application of a statute forbidding access to all streets and other public facilities. Although the statute here on its face precludes all street assemblies and proceeds, it's not been applied and enforced by that. City officials who testify for the state clearly indicate that certain meetings and parades are permitted, even though they are effective obstructing traffic prior to prior approval. This was confirmed in oral argument before the court. The statute itself provides no standards for the determination as to which assemblies are permitted to be prohibited, nor their administrative regulations. So this might fail in the fact that it's overly broad. A situation is thus the same as if the statute itself expressly provides there can only be peaceful parades or demonstrations in unbridled discretion of local authority. That's not going to fly. Yeah, so this is either going to turn on the facts that are specific to this case, they were not in fact obstructing, or it's going to turn on the facts that, it's unbridled discretion, right? Yeah. In which case, this case on the Supreme Court doesn't apply. Or apologize, the case in the Capitol doesn't apply, because it doesn't say, like, you can parade, if you get approval. It just says no parading to disrupt Congress. You can't, there's no discretion for the Capitol Police to allow that. So it's not like they'll allow some demonstrations that would interrupt Congress inside the interior and not others. Or even that will allow some parades and not others inside the Capitol. There's no discretion. So, they can't ever allow it. So it doesn't quite apply. As opposed to this example, where they were allowed by the law to allow it or not, which meant that they had unbridled discretion to approve a speech or not, which is too much, right? That's too much, too broad for a governmental authority. Yeah. The court has recognized that such broad discretion public officials allow us to determine which views will be permitted and which not. Also inherent in such systems allowing parades or meetings only with prior permission is obvious danger to be deprived of equal protection right. So this would be another example why the statute in question on the federal law is different, because it doesn't say that you can parade with permission. It says you can't parade, period. It doesn't give authority for Capitol Police to allow it under some circumstances. It's a universal prohibition, which takes away all your equal protection problems as far as the police are concerned. Yeah, okay. This is, of course, undisputed. Now, this is, again, the key holding that's going to be applicable to our current legal matter. It is, of course, undisputed that appropriate, limited discretion under properly drawn statutes or ordinances concerning time, place, duration, or manner of use of streets for public assemblies may be vested in administrative officials, provided such limited discretion is exercised uniformly upon the facts of each application, which, for example, would be denial of all applications. That would be a uniform application, just straight up denial. Or any other thing that would be objective and would just, like, you have to check boxes. But no is a uniform application. So here, yeah, the Supreme Court case doesn't apply. The Supreme Court case does not apply to the federal statute dealing with the thing, right? Because going back to the charge, willfully and knowingly paraded, demonstrate, and picketed inside any United States Capitol building. So that's just a universal prohibition. It's a universal prohibition. There's no discretion like there was in Baton Rouge for the police to say yes and say no. Unlimited discretion, notably. So here it's just like, how about no? Which is uniform application of the rules. That's pretty uniform, just how about no? So the case does not read on the present situation, but it was still a good case for us to discuss because it shows some of the legal principles involved, right? It shows like what can be done and what can't be done, right? You can limit things, you can limit the parading, you can limit it time, place, manner, you can allow some things and not others, as long as, it's universal, as long as, and then even if universal, that might not necessarily be sufficient, because that goes a long way to helping, right? That would just be like the abuse of authority, right? If it allows for unbridled discretion, that's just the government can approve based on speech they like and don't, and that's fucking no-no, because why would that be a no-no? Why is unbridled discretion a no-no? Because at that point, it becomes a subject matter viewpoint-based discrimination. That's why. If you allow the government to have unbridled discretion as to be like, yes, we can decide to allow certain parades and not others based on our own whims and fancies. What does that sound a lot like? That sounds a lot like a viewpoint-based discrimination to me. Hey, we can allow the speeches we like and the parades we like and we don't like. Whoa, ho, 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 right? So we've moved past the time, place, manner restriction into, yes, we, the government, in our infinite and unbridled discretion, can allow it when we fancy. No, I don't think so. Now, if you have some rules that you apply universally, sure. That would be a helpful start, although not necessarily the end. Because even if you have the universal rules, right? Even if you have the universal rules, now at least we don't have an equal protection nightmare. Thank God. Now at least we don't have a due process nightmare. Thank God. So we got rid of that problem. But we still have to do a First Amendment analysis on top of all that. We still have to get into a substantial government interest and whether or not it's substantially related to that interest. So even with like a universal rule, like, for example, suppose a city passed a regulation that says no parade shall be allowed ever on any of our streets except from, like, I don't know, 12 to 12:30 p.m. on alternate Tuesdays, right? Well, that's a universal rule. It's a universal. It's time, place, manner, but no, that's not gonna fly. I'm sorry. That's way too broad for whatever interest. Yeah, we need our streets to function, and so we're gonna only allow this. So 12 to 12:30 on alternate Tuesdays. It's like no court's gonna allow that, right? So still on top of all that, still would have to do a First Amendment analysis. So as it applies to this capital thing, right? We don't have a due process problem. We don't have an equal protection problem. And we don't really have a First Amendment problem, because is there a substantial interest in ensuring that, Congress can do its job? Yeah. Is the restriction of preventing the parading in the building substantially related to that? Yeah. So I think we're fine on the First Amendment analysis too. What about organized by Democrats most always on the House floor protests at such time of convenience? Well, it depends who's doing it. Is it members of Congress who are doing it? And members of Congress, they get a freebie, right? So if it's members of Congress that are doing it, they get a freebie. If it's not members of Congress who are doing it, then, those people can be arrested and often are, often for different charges, incidentally. So for example, like in the Kavanaugh hearing, when like person after person stood up and like disrupted the hearing, right? That isn't a parade. Right, that's not considered a parade, demonstration, or picket, so it doesn't quite fall within the statute. But there is another this goes into like the exact language of statutes, right? But there's another statute that applies for haranguing, which is what that's called, right? So when you just stand up and like just disrupt the thing, that's called a harangue. I don't know why it's called that, but that's what it's called, right? So those guys get arrested on a different charge of haranguing. And those guys were appropriately punished and sentenced to very low things because the penalties are very low for the haranguing for a first offense. But, that's what they were guilty of in that situation. So, yeah, a lot of those people in like the Kavanaugh hearing were arrested and charged and convicted and basically let off, with basically a slap on the wrist. But that's the relevant law as it applies in that circumstance because, that was not considered a parade, demonstration, or picket. So again, you have to go to these exact statutes and exactly what does apply or does not apply and why it does not apply, so yeah. Filibuster, again, if it's a member of Congress doing it on the floor, you get a freebie. All right, if you are a member of Congress and you are doing it by your speech on the floor of Congress, you get a jail out of free card because the Constitution says you do. So if you're a member of Congress and you are disrupting things by your speech, you, my friend, on the floor, and almost certainly in committee hearings, you get a freebie. You may be expelled from Congress, but you can't be arrested and charged with an offense because the Constitution says so in the Speech and Debate Clause. Yeah, so that's what it is. Wouldn't the fact that some previous protests happened at the Capitol, no one was arrested? I don't know that that's factually true. Again, a lot of people were arrested for prior protests. And whether or not it was a parade, demonstration, or picket to fall within the scope of this statute is a whole nother thing. But as I pointed out, like in the Kavanaugh hearing, like a lot of those people were arrested. Also, you know, there's prosecutorial discretion, which goes a long way, unfortunately. So to show an equal protection violation for that, you're going to have a difficult time. I'm not saying it's impossible, but you're going to have a difficult time, right? To show that like it's only people of certain persuasions, or only people like, this can also be selective prosecution is what it's called. I had to think of it for a second. Yeah. Selective prosecution. So to like make a successful claim for selective prosecution, to say like, you know, they're targeting me for improper reasons, you're going to have a difficult time. But you can demonstrate that by like a law that's like never used, that's like broken out for you. For example, one of the things that one of the defenses, for example, for Hillary Clinton, for things she did, was one of the statutes that they tried to bring her under was like, the last time it had been used was like 80 years ago. It's been used like 3 times in U.S. history. So like one of the problems with charging Hillary under that law was, even though she might be under technical violation of the letter of the law, the fact that like no one is prosecuted against it ever makes it a real big selective prosecution problem. So there was that problem among many others for like Hillary Clinton for some of the stuff. Again, I'm not saying it's good. I'm just telling you the law, and it applies both ways, as we've said, right? It applies both ways. So if you're going to try to make a selective prosecution claim, you're going to have to like show that they are, you know, like basically never doing this against Democrats, and I don't think you can show that. A lot of the cases of Democrats are doing a lot less, so they're being charged with lesser things. But again, you have to go to each case and look at the relevant criminal law that does apply, and you'd have to show like a systemic pattern and blah, 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 blah. So selective prosecution claim is hard. $20 from Etchemer's Treatise. Good interactive section. No problem. I'm here to help. Yeah, prosecutorial discretion goes a long way. So if you want to try to beat prosecutorial discretion with selective prosecution, that's a tough one. But it can be done. You know, it would help a lot to show that, you know, basically the statute is never used except for you, which would have gone a long way for Hillary Clinton, for example, or, you know, that it's applied massively unequally. But that's a tough road to hoe. So I'm not saying the January 6 people can't try to argue selective prosecution, but I wouldn't imagine it would be successful. It'd be tough. Join Rumble. Your truth will get you banned on YouTube. Why? I mean, the truth is equally... I just said just now, why should the truth get me banned? I mean, I just said just now that Hillary Clinton probably can't be prosecuted for like that one offense because it shouldn't, because of selective prosecution problems, right? So my analysis is even. Like, you can't accuse me of that much bias because I'm applying the law evenly. I'm like, well, here's one of the problems with prosecuting Hillary Clinton. It's like, you have a selective prosecution problem, so, you know, probably you have an issue there. So it's like, how much bias can I have when I'm saying, yeah, well, you know, here's some problems, and here's why you might not be able to do that, and here's some, it's like, how much bias is there when I'm saying, like, you know, it's a problem for prosecuting a Democrat? This is one of the things that I get a little bit irritated with on my channel sometimes. People accuse me of bias. I'm like, how biased can I possibly be, man? I'm saying there's problems if you want to prosecute Hillary Clinton. That's how biased I am. I mean, come on. You know? Like those FARA violations, never used before in 70 years, that's not true. FARA violations are rare, but I don't think they're that rare. FARA violations do come up, but I don't believe it's true that they've never been used in 20 years. I seem to remember other FARA cases. They're uncommon, to be sure, but I don't think it's that rare. So I don't think we're quite in that territory. So I think you might be mistaken on that, on FARA. I could do a quick Westlaw search to check, but I don't think that's factually correct. I don't think we're in quite the same posture as FARA. It's not your bias, it's Google's. Well, you would presume Google would be biased in favor of Hillary Clinton, but yeah. And I tried, yeah, thank you, Shane, for saying I do a good job of showing how the law is evenly applied. Right. This is like, I'm not necessarily saying that everything that, like, you know, Comey did was proper, but one of the reasons not to prosecute was because of like one of these problems. Like one of the statutes didn't apply. One of the statutes didn't apply by its own terms. The statute that kind of did apply by its own terms, like, is never used ever. And then the other one was like Public Records Act, but it's like, you know, so Comey, I don't think was necessarily wrong for a variety of reasons. So this, although I don't know that Comey should have been the one making that announcement, because that really should be coming from the DOJ, not from the FBI. But still, I mean, I don't think he was necessarily wrong, despite, you know, my misgivings, which are many with what Hillary Clinton did. I don't know that his analysis was necessarily wrong, as frustrating as that might be. Ooh, someone citing an old case. The common law is the real law. The supreme law of the land. Codes, rules, regulations, policies, and statutes are not the law. So we're citing an old case. 61 Wisconsin. All right, first of all, it's Wisconsin. So I don't know what Wisconsin thinks as a member, because it's Wisconsin, right? So I don't know what Wisconsin said as a matter of its law, but obviously that's not federally applicable. But let's take a quick look at, you know, whatever this case says in terms of this. This is interesting. So Wisconsin said it probably does not mean it literally, but let's take a quick look and see what it actually says. This is probably being taken out of context. Although, who knows? Maybe it's not. So let's see. We can take a look. I'm enjoying talking to you guys. Self versus Ray. Let's see. What is this? Self versus Ray. Oh, it's Washington, not Wisconsin. I think you gave me the wrong abbreviation. 61 Wash, second 261. Oh, WN is Washington, isn't it? Yeah, my bad. Not Wisconsin. My bad. Sorry, Wisconsin. My fault. So Supreme Court of Washington, 1963. 61 WN. Damn it, it is the Washington State. Damn it. Try to look smart and I make myself an idiot. I'm sorry. That's my bad. We can make mistakes, though. We learn from our mistakes. Let's take a quick look at what this says and see if it stands for the proposition that this person's quoting it for. Right? Because sometimes they say things as like an aside. And, you know, you have to read it in its full context, obviously, so it's okay. Yeah, WA is Washington, WI is Wisconsin, yeah, but WN for what? WN for legal citations for Washington. WN. They don't do the postal code thing. It's WN. So, yeah, I agree with you. Comey didn't really have the power to do it. That, I think I said as much, right? I think I pretty much said that. I think it was kind of dubious it really should come from the DOJ, but I don't think he was necessarily wrong. So yeah, I agree with you. That was not Comey's role. So there is a problem there. I think I said as much, but you know. All right, let's see what we got here. So what'd you say? It's not actually that old. I mean, 1963 isn't that old. That's fair. Let's see what it says. In 1963 isn't that old. The reason, by the way, I thought it was old. The reason I thought it was old, and it was a mistake on me reading it initially. But the mistake on me reading it initially when I saw WN, the first thing that came to mind is I thought it was an old Supreme Court citation format. Because the really early cases of the Supreme Court are not usually cited something U.S. something. The really early ones are cited usually by the reporter, which I don't even know what they are off the top of my head. But like you'll see Supreme Court cases really early in the Supreme Court that aren't. You can cite them something U.S. something, but usually they're cited by the reporter. So I thought initially it was like when I saw that I thought, oh, this is a really old Supreme Court citation. That's why I thought it was really old. So I screwed up my initial read on a couple different ways. So anyways, let's just ignore that part. Let's just ignore that part. Alright, so now I have to find this thing. Let's see. Blah, 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 blah. I have to find where this thing is. Is it in here? Hold on. I hope so. Let's see. Comment. Convert to OCR. So I can find this thing. Can we talk about Lindsey Graham's tweets tonight? I don't know if they are, so I have nothing to offer on that subject. Find. It's not saying the word common law. It's not saying it appears at all in the case. Common law is the real law. So I just did like a search and I can't find it. Let me just speed read it again real fast and see if it's like an OCR problem. It doesn't seem to use this language at all. It doesn't seem to use this language at all in this opinion, unless I'm just massively misreading it. Yeah, I'm not seeing this language at all, in this opinion. Let me just try popping it into Google Scholar real fast and see if it pops up. No. Yeah, I'm not seeing in this case, and putting the phrase in quotes doesn't pop anything on Google Scholar. I think that this is not a thing. I can double check though by going to Westlaw and seeing if it's ever popped up in an opinion ever in the history of time. So let me just go to the big boy database real fast and see if it's in Westlaw. Search every case ever. Big boy database, including a lot of unpublished ones, incidentally. Search everything. Give me all the things. And let me try putting in quote marks without the period. Well, I won't put in quote marks because maybe the punctuation's wrong. No. Let me just try the common law as the real law. Let me just try that phrase in quote marks. See if that phrase has ever appeared ever in a hit case ever in the history of time. It's appeared twice. Oh, wait. Here it is. Here's a brief. Oh, no, wait. It says, okay, it says you're right. Then why can't I find it? What am I doing wrong? What the hell am I doing wrong? Because here's a brief which says it's in the case you cited. What the hell? I mean, we could just read the entire case and see if the phrase appears. Which I'm tempted to do at this point. Yeah, Selfie Ray, 261. Okay, I mean, okay, so two briefs say it's in there. Here's one from New York. Let's see if New York has anything. And that's just an argument the court rejects. That's an argument the court rejects. All right, so let's just read through this entire thing, because two briefs say it appears in this case, and I don't think it does. So let's just read it and see if it appears. Why not? Why not? Let's see if I'm wrong, or OCR's wrong, or these briefs are just making up shit. Did some lawyers make up some shit sometime? Let's find out. Okay, here it is. 61 WN, 2nd, 261, 1963, right? That's the right citation. Self versus Ray, Supreme Court of Wisconsin, Supreme Court of Washington, en banc. Let's just read this entire thing. I did word search the phrase. I couldn't find it. I couldn't find the phrase. So, but two briefs said it's there. So two briefs. There's a brief. There's a brief in 2021 that cites it. Well, it's actually one brief, actually, that cites it. There's a brief. Yeah, it's a brief before a case before the 11th Circuit. So some attorney before the 11th Circuit said that it's here. So it's the one brief who says it's here. So we're going to read it and see if the Supreme Court's just, see if they're making up shit. This matter is before us on a petition for a writ of habeas corpus, which raises the question of constitutionality of the laws of 1919. Petitioner was convicted of the crime of murder in the first degree in the Superior Court for King County. By special verdict, the jury inflicted the death penalty sentence, which accordingly imposed on June the 17th of 1960. Petitioner appealed this court, where the judgment and sentence were affirmed. His application to the United States Supreme Court for writ of certiorari was subsequently denied. After filing the habeas corpus petition in this court, execution of the judgment and sentence was stayed by order of the Chief Justice pending the consideration and disposition of the petition in this proceeding. Petitioner in this court raises a question of constitutional law, with Section 1, Chapter 112, Laws of 1919, which provides that the jury, in a prosecution on the charge of murder in the first degree, shall, by special verdict, determine whether the death penalty shall be inflicted, enacted in violation of the Constitution, which provides that no act shall ever be revised or amended by mere reference to its title, but the act revised or section amended shall be set forth at full length. Okay, so according to the Constitution of Washington, at least at the time, it says that no act shall be amended by mere reference to title, but shall be amended at full length. Okay. So, all right. So we're arguing a violation of the state constitution. Fine. Stop stressing. You're among friends. I'm not stressing. I'm just like, you know, I'm not stressing. I just want to make sure I get it right. Right. I want to, because if I'm not stressing, am I? But I'm just like, if I make a mistake, I want to correct it so I will be less stupid. Right. This is not like the other day where I was challenged by what's his name, who refused to let it go after I disproved him 8 different ways. Right. Because he just refused to give up. Here there is a brief. There's one brief that says that it's here, and I can't find it. But like, if I'm wrong, I'd like to know I'm wrong, and I'd also like to know what context the statute is using it. So like, I want to give you good legal information, and if I'm wrong, I'm wrong, and I'd like to and if it says it, I'd like to know why it says it, and then I can like opine about that. So like, you know, let's try to get it right. And there seems to be some evidence that suggests that, you know, I'm getting it wrong, so let's try. Okay, petitioner's brief sets forth the following question. Is a statute amendment on its face, and in fact, of a prior legislative act violative of our state constitution, where it purports to amend a section of a code compilation, makes no reference to the legislative act sought to be amended, and requires reference to a prior act to ascertain legislative intent? Sounds promising as a matter of state law. Sounds promising, but then again, this is the I keep saying Wisconsin. This is the Washington State Supreme Court, so they're the one that gets to interpret the state constitution. But it sounds like a plausible argument here. The basis of the assertion that both the purported amendment of the laws relating to punishment of first-degree murder by law and the amendment of the act by laws of the chapter were in violation of the above-quoted constitutional provision is founded on the legislative history of their antecedents. Starting with the Criminal Code in 1909, which provided in Section 140, the punishment for first-degree murder should be either death or life imprisonment by state penitentiary in the discretion of the court. Our attention is called to the following statutory enactments. Now we're going to go through a little bit of legislative history. Laws of 1911, Chapter 7, page 8, which authorized the legislature to refer to Remington and Bollinger's annotated codes and Statute of Washington, hereinafter referred to as Rem and Ball Code, when amending or repealing existing statutes. So there was some statute that allows the legislature to refer to some compilation in amending, but which still might be a violation of the state constitution. But okay, there's a statute apparently. Law of 1913, Chapter 165, page 581, which purported to amend some statute of the relevant code by abolishing the death penalty and prescribing life imprisonment in a state penitentiary as the sole punishment for first-degree murder. Law of 1915, Chapter 5, page 18, which adopted the code as the official compilation of existing statutes up to and including the year. So now Washington is by law saying this compilation of laws is now the official law. Like they previously said we could amend the official law by reference to the same thing, which is not quite the same thing. And now they're just saying, yeah, that thing is the law. So it's the law now. So great. Apparently. Or maybe not, because whether or not that's sufficient under the Constitution is still an open question, but okay. In principle. Some law of 1919, which provided that the section of the relevant law, the blah, 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 is amended to read as follows, blah, 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 blah. Petitioner's contention is that since the last quoted amendment is invalid for the reason stated above, which would be because, the reason would be because it is that this section is amended to read as follows, and apparently the idea is at least that we didn't quote it in full. We only quoted it by reference to its statutory number, or if not in this law, because that doesn't seem to quite fly here, because it does seem to quote it in full, but maybe under something in the chain it failed for that reason. So like this amendment would be invalid because some prior amendment was invalid along the way, might be the idea. Okay, so somewhere along the way the chain failed, and so this amendment doesn't make any sense. Maybe that's what we're going with. All right, so let's read some more. Petitioner's contention is that since the last quoted amendment is invalid for reasons stated above, the only valid reason now is the effective law of 1909, which contains the following provision, which goes back to the sentencing of the court. Fine. In support of this contention, petitioner relies mainly on a recent en banc decision. That case involved the law of whatever, 1889 to 1890, Chapter 7, Section 15, relating both to original incorporation of municipalities and annexations thereto. In the original compilation of the Revised Code of Washington, which was authorized by the legislature in 1941, the provisions contained in Section 15 were divided into two code sections: Revised Codes of Washington, whatever, relating to the organization of municipal corporations, which is to say cities, and Revised Code of Washington, whatever, relating to permissible area to be included in a fourth-class city. Out there. Thereafter, in the enacting laws in 1951, Chapter 109, the legislature purported to amend the Revised Code of Washington, Section blah, 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 as derived from Section 15 in part, without setting forth the amendatory bill in the full text of the original section as amended. A majority of this court was of the opinion that the attempted 1951 amendment was invalid because of the failure to comply with the Constitution. So apparently in some prior thing relating to what cities are and different classes of cities, because apparently that's a thing, apparently they just referred to the section number, and that's not going to fly, because that's what the Constitution seems to say. Okay. While all 9 judges concurred in affirming the trial court's dismissal of the action to enjoin the proposed annexation, they did so for different reasons. 4 judges expressed an opinion that the original code committee created by the law of 1941 had produced 2 volumes of a compilation of laws in which the legislature had adopted by reference only as prima facie compilation of the state law. These 4 judges stated that reason as follows. Okay, so yeah. 2 laws disagreed with that reasoning, believing that the article had been violated in the amendment of Section 15. That section as amendment should be enforced. Okay, and some other stuff. And these references to Section 2392 in the amended Tory Acts were to official code, which at this point was the Remington and Bollinger's annotated code and statutes of Washington, because again, apparently at some point we've adopted that officially, which the legislature had adopted. The code section referenced in the 2 amendatory bills and the section amended in each instance set forth in length. Thus, in our opinion, Law of 1999, Chapter 112, Section 1 is a valid enactment as amended prior Tory Act did not violate the Constitution. Okay, so it seems like there was agreement that it was improper, but a disagreement as to why. So there was no controlling opinion, apparently, as to why, which means there's no controlling opinion. Right, so we agree that the statute's unconstitutional, but we can't come up with enough votes to say why. So basically, that's basically a decision that binds kind of that case only, because I don't know if they have the equivalent of what's it called in the federal case when you have to combine votes. Is that called Smith, or is it called something else, where you like have to conjure like votes to try to figure out what a majority opinion is? Apparently they don't have that in Washington, so apparently we just have no controlling opinion. So all that we agree on is the result. Period. Okie doke. In the reply brief, petitioner argues it is extremely hazardous for the legislature to amend prior laws by reference to code compilation sections. However that may be, the question before us is whether the legislature, in amending the 2 sections involved in this case, set them forth at full length as required by the Constitution. We hold that it did comply with the provision applicable to the amendments, and the code reference was proper since the legislature had officially adopted it. It follows for the petition of writ of habeas corpus is denied, the stay of execution dissolved, and respondent is directed to produce petitioner in the Supreme Court of King County for saying the time of execution is so ordered. So yeah, the phrase doesn't appear anywhere in the statute. The phrase that this one brief apparently says is here is just not here. We've read the opinion. It's not here. Is it in a footnote? Is that what we're going with? Is it a footnote? No, there's only a 1 footnote. So yeah, so some lawyer basically once just made it up. Some lawyer one time just totally made it up and just cited a thing that doesn't stand for that proposition, which unfortunately does happen. This is one of the reasons that, you know, in briefs you actually have to go read the case, because sometimes lawyers stretch the truth. In this case, seemingly just making it up out of nothing. But yeah, so the one lawyer who said it's a thing, it's not a thing, so it's not a thing. And okay, so I mean, no, the case does not stand for the proposition that the common law is the real law and statutes aren't. It says nothing even remotely close to any of that. So fun. Nothing even remotely close to anything like that. Yeah, like Littlefinger maybe. Yeah, like that, right? So it's like, oh, well, one brief one time said it said that, but no, that one lawyer was full shit. It doesn't say anything close to that. Lawyers stretch the truth sometimes, but man, this is stretching the truth a lot, man. Like this is an unethical stretching of the truth in my mind. Like this is a lot of stretch. I don't think we're even remotely close to that, but that's just me. That's just me. Yeah, we read it. It's like, yeah, it doesn't say anything even remotely close to that. That citation's bullshit. And by the way, like if you get called out by this by the other side, who points that out, right? So this is another reason not to do it. Because if the other side takes notice and says basically you're full of shit and brings it to the attention of the court, it hurts your credibility massively, right? So if you point out to the court of appeals, hey, that doesn't say anything even remotely close to that, the other guy's lying, and they catch you out, you're gonna have a bad time, man. So you don't want to do that. Because if they catch you, man, it's not going well for you, right? They're going to they're not inclined to believe what you have to say, and your credibility before the court or the tribunal, as you imagine, goes a very long way. And when you don't have credibility before the tribunal, it really goes a long way. So yeah, you don't really want to lose your credibility. So this is the kind of thing that if you cite this, if you do this, you're having a bad day. So no. So yeah, so that's all I have to say about that. So I guess I'm going to end the stream now that we've talked about many, many other subjects other than the Capitol Riot series. But thank you. Because, you know, we look these things up and we discuss why. We discuss why this isn't like that one Supreme Court case that one time, and why when some guy I mean, I can't blame your friend totally for making up this bullshit quote, because the bullshit quote comes directly, like almost word for word, the bullshit quote comes almost directly from some attorney's brief. So some attorney once said it exactly almost word for word, that what you said, and yeah, it's just crap. So, no. But we have fun. I'm going to sign off for now, ma'am. If you've enjoyed this stream, in which we in no way encourage anyone to riot or disobey lawful authority, if you've enjoyed this stream as we try to reclaim our, channel from YouTube, please remember to give it a like, subscribe, all the things. If you enjoy the fact that we go into a very in-depth discussion where we discuss about other things that are kind of tangentially related because I have some energy and it might be interesting, please remember to like, comment, subscribe. I do this stuff that you hopefully will find some value out of it. And, try to provide some in-depth analysis and try to provide some logically reasoned opinions about stuff. So, if you enjoy all that thing, please remember to like, comment, subscribe. Did you know for a mere 99 cents, you too can become an uncivilian? It's true. If you hit the join button or you hit the link that Streamlabs has been telling you about from time to time, to hit the join button, you will get your name on screen. As you can see, these fine people have gotten their name on screen. How did they get their name on screen? By being an uncivilian. Well, how can I become an uncivilian? It's very, very easy. All you have to do is hit the join button or hit the link from Streamlabs for a mere 99 cents a month. It's true. You too can become an uncivilian. And you get a cool little icon by your name, the Scales of Justice. That's pretty badass. And also you get your name on stream to show that you're a supporter of the channel, which is also pretty badass. See, you can get these wonderful benefits for 99 cents. It's literally the least they'll let me charge you. So, there's some benefits for you to help support the channel. So until later, my friends, I hope all's well. Cheers, my friend, and goodbye.